Margaret Thompson sat at her kitchen table in Tucson, Arizona, staring at the stack of collection letters that had arrived that morning. At 73 years old, this retired schoolteacher was surviving on just $400 a month in Social Security benefits. The letters demanded payment for old credit card debts, medical bills, and other monthly obligations totaling over $2,800. Margaret hadn't slept properly in months, lying awake wondering how she could possibly pay rent, buy groceries, and satisfy these relentless debt collectors. What Margaret didn't know was that she had every legal right to ignore most of these payment demands. In fact, she was what legal experts call judgment-proof, meaning creditors couldn't legally touch her Social Security income or force her to pay debts that could leave her homeless and hungry. I'm Judge Patricia Williams, and for nearly 32 years, I've been protecting seniors from financial predators who prey on their lack of legal knowledge. I've seen thousands of cases where elderly Americans like Margaret were bullied into paying debts they had absolutely no legal obligation to satisfy. Today, I'm going to reveal 6 specific types of monthly payments that seniors can legally ignore and the federal protections that make this possible. Here's what we'll cover. First, I'll expose the Social Security protection laws that shield your benefits from most creditors. Second, we'll discuss time-barred debts and why many of your old bills can no longer be legally collected. Third, I'll reveal the judgment-proof status that protects seniors living on fixed incomes. Fourth, we'll explore medical debt protections that most seniors don't know exist. Fifth, I'll show you how to use cease and desist letters to stop collector harassment forever. And finally, we'll discuss the homestead exemptions that protect your primary residence. But before we dive in, I need you to understand something crucial. The debt collection industry generates over $7 billion annually by convincing people like you to pay debts they often cannot legally collect. They specifically target seniors because they assume you don't know your rights and will be intimidated into compliance. If you're watching this and feeling overwhelmed by collection calls and threatening letters, please hit that like button right now. Share this video with any senior in your life who's struggling with debt collectors, and comment below with just the word protected so I know you're ready to learn about your legal rights. The truth is, federal law provides powerful shields for seniors that most people never learn about. The Fair Debt Collection Practices Act, Social Security protection statutes, and state exemption laws create a fortress around your essential income and assets. But debt collectors are counting on your ignorance. They use fear, intimidation, and outright lies to trick you into voluntary payments on debts they cannot legally force you to pay. Margaret's story has a happy ending. Once she learned about her protected status, she sent cease and desist letters to every collector. The harassment stopped immediately. She kept her full Social Security check, maintained her modest apartment, and regained her peace of mind. Today she lives comfortably within her means, free from the terror that once consumed her nights. What Margaret discovered, and what I'm about to share with you, could save you thousands of dollars in unnecessary payments. More importantly, it could restore your dignity and end the sleepless nights caused by collector harassment. The debt collection industry doesn't want you to know these laws exist. They profit from your fear and confusion. But knowledge is power, and today you're going to learn exactly which payments you can legally refuse to make. Let me start with the most important protection you have. Your Social Security benefits are absolutely untouchable by most creditors. Federal law specifically prohibits debt collectors from garnishing Social Security retirement, disability, or survivor benefits to pay credit card debt, medical bills, personal loans, or most other consumer obligations. This protection exists because Congress recognized that Social Security is your lifeline, money you need for basic survival. The law states that your Social Security benefits are exempt from collection, period. But here's what's crucial. This protection only works if you receive your benefits through direct deposit and keep them in a separate account. The federal government requires banks to automatically protect Social Security funds when they're directly deposited. Your bank must protect at least 2 months' worth of benefits from garnishment, even if a creditor obtains a court judgment against you. So if you receive $1, $500 monthly in Social Security, your bank must protect $300 in your account from any collection attempts. Now, here are the first 3 types of monthly payments you can legally ignore if you're living solely on protected income like Social Security. First, credit card minimum payments. If your only income is Social Security, credit card companies cannot force you to make monthly payments. They can call and send letters, but they cannot garnish your benefits or force payment. You can literally ignore their payment demands with complete legal immunity. Second, medical debt monthly payment plans. Hospitals and medical providers love to pressure seniors into monthly payment arrangements for old bills. But if you're judgment-proof because you live on Social Security, these payment plans are voluntary. You cannot be forced to participate, and your benefits cannot be touched to satisfy medical debt. Third, old personal loan payments. Whether it's a payday loan, personal loan, or installment debt, collectors cannot garnish Social Security to collect these debts. If these loans are your only debt and Social Security is your only income, you can cease making payments without legal consequences to your protected income. But debt collectors don't want you to know this. They'll use every scare tactic in the book. They might say things like, "We'll garnish your Social Security," or "You'll lose your benefits if you don't pay." These statements are completely false and actually illegal under federal law. I've seen collectors tell seniors they'll lose their housing, their medical benefits, or face criminal charges for unpaid debt, all lies designed to frighten you into voluntary payment. The truth is, being unable to pay consumer debt is not a crime, and your Social Security benefits are specifically protected by federal statute. Here's a real example. Robert Martinez, 68, from Phoenix, was paying $400 monthly to various creditors from his $1,300 Social Security check. This left him with barely enough for rent and groceries. When he learned about his protected status, he immediately stopped all voluntary payments to unsecured creditors. The collectors threatened and blustered, but they couldn't touch his Social Security. Robert now keeps his entire check and lives with dignity. The key phrase here is unsecured creditors. So these are creditors who don't hold collateral for your debt. Credit card companies, medical providers, collection agencies buying old debt. They have no legal claim to your protected Social Security benefits. However, there are limited exceptions. The federal government can garnish Social Security for unpaid federal taxes, defaulted federal student loans, or court-ordered child support and alimony. But private creditors, the vast majority of those harassing seniors, have no such power. Remember this fundamental truth. If Social Security is your primary or only income source, you are likely judgment-proof against most creditors. This means even if they sue you and win, they cannot collect from your protected income. Now, let's talk about one of the most powerful protections seniors have that almost nobody knows about: time-barred debt. This legal concept could immediately eliminate your obligation to pay thousands of dollars in old debts. Every state has laws called statutes of limitations that set deadlines for creditors to sue you for unpaid debts. Once these deadlines pass, typically between 3 to 10 years depending on your state and the type of debt, the debt becomes time-barred, meaning collectors lose their legal right to sue you for payment. Think about this. If you have credit card debt from 2018 and you live in a state with a 4-year statute of limitations, that debt became legally uncollectible in 2022. Yet debt collectors will still try to intimidate you into paying, hoping you don't know about this protection. Here's what makes this especially important for seniors. Debt collection companies often buy old debts for pennies on the dollar, then aggressively pursue seniors who they assume won't fight back. These companies are literally trying to collect debts they have no legal right to pursue. Dorothy Chen, 71, from Sacramento, discovered this the hard way. She was making monthly payments on old department store credit cards from 2015, debts that had been time-barred for 3 years under California law. When she learned about statutes of limitations, she immediately stopped paying. The collectors threatened to sue, but they couldn't. The law prohibited any legal action on those old debts. The fourth type of monthly payment you can legally ignore. Any debt that exceeds your state statute of limitations period. If creditors contact you about old debts, you have the right to demand proof of the debt's age. If it's time-barred, you can tell them to stop contacting you entirely. Federal regulations now specifically prohibit debt collectors from suing or even threatening to sue for time-barred debts. This means if a collector tries to intimidate you by threatening legal action on an old debt, they're breaking federal law and you can report them. But here's the trap many seniors fall into. Making even a small payment on a time-barred debt can revive it in many states, restarting the clock and giving collectors a fresh opportunity to sue. Never make payments on old debts without understanding their legal status first. The fifth payment you can legally ignore. Any monthly payment demanded by collectors who cannot provide proper debt validation. Under federal law, collectors must prove you owe the debt they're trying to collect. If they can't provide documentation showing the original creditor, the amount owed, and your connection to the debt, you can dispute it and demand they stop collection efforts. I've seen countless cases where collectors were pursuing seniors for debts that weren't even theirs, wrong person, paid-off accounts, or fraudulent charges. Always demand debt validation before making any payments to collectors. The sixth and final payment you can legally ignore. Any debt where the collector has violated federal law in their collection efforts. If debt collectors have called you before 8 a.m. or after 9 p.m., used profane or threatening language, misrepresented the amount owed, or threatened legal action they cannot take, they've violated the Fair Debt Collection Practices Act. These violations can provide you with legal defenses against the debt itself. Remember Arthur Williams, 75, from Tampa? Collectors were demanding $300 monthly for old medical debt, while calling him names and threatening to have him arrested. These illegal tactics gave Arthur grounds to file a complaint with federal regulators and ultimately get the debt dismissed entirely. The debt collection industry relies on senior citizens not knowing these laws exist. They count on your fear, your desire to do the right thing, and your lack of legal knowledge. But now you know better. Let me share something that might shock you. The vast majority of debt collection lawsuits against seniors result in default judgments because people simply don't show up to court. They're so intimidated and overwhelmed that they surrender without even fighting. This is exactly what debt collectors count on. But here's what they don't want you to know. Even if a creditor sues you and wins a judgment, they still cannot touch your protected income if you're judgment-proof. A judgment is just a piece of paper unless the creditor can actually collect from you. Think about what judgment-proof really means. It means you have no non-exempt income or assets that creditors can legally seize. For most seniors living on Social Security, pensions, or disability benefits, this protection is absolute for unsecured debts like credit cards and medical bills. Let me tell you about Helen Rodriguez, 69, from Albuquerque. Debt collectors sued her for $8,000 in old credit card debt. Helen was terrified and considered emptying her small savings account to pay them off. But when she consulted with our legal clinic, she discovered she was completely judgment-proof. Her only income was $100 monthly in Social Security. Even though the creditor won their lawsuit, they couldn't collect a single dollar from her protected income. Helen learned she could have simply ignored the entire collection effort. The judgment meant nothing because there was nothing for them to take. She kept her savings, maintained her dignity, and the creditor eventually gave up trying to collect. This brings us to a crucial point about homestead exemptions. Many states protect your primary residence from creditors through homestead laws. These exemptions can protect anywhere from $25,000 to over $600,000 in home equity, depending on your state. For many seniors, this means even if you own your home outright, creditors cannot force its sale to satisfy unsecured debts. In Florida, the homestead exemption is unlimited. Creditors cannot touch your primary residence regardless of its value for most consumer debts. In Texas, you can protect up to $75,000 if you're single or $100,000 if you're married. Even in states with lower exemptions, most seniors' modest homes are fully protected. Now, let's address the elephant in the room. The emotional manipulation debt collectors use against seniors. They know you were raised to honor your debts, to keep your word, to do the right thing. They exploit these values to extract payments you're not legally required to make. I've heard collectors tell seniors, "Don't you want to pay your debts like an honest person?" Sure, what would your children think if they knew you weren't paying your bills? These are psychological manipulation tactics designed to bypass your legal protections by appealing to shame and guilt. Here's the truth. There is nothing dishonest or shameful about using legal protections that Congress and state legislatures specifically created for people in your situation. These laws exist precisely because lawmakers recognize that seniors on fixed incomes need protection from aggressive creditors. You didn't create the financial circumstances that led to unpaid bills, medical emergencies, job loss, reduced income in retirement. These are life events that affect millions of Americans. The law acknowledges this reality and provides protections accordingly. When collectors try to guilt-trip you into payment, remember that they bought your debt for cents on the dollar. They're not trying to help the original creditor. They're trying to profit from your financial hardship. Your legal protections exist specifically to prevent this exploitation. Standing up for your legal rights isn't stealing or cheating. It's using protections that society has deemed necessary and appropriate for people in your circumstances. Here's something debt collectors absolutely don't want you to discover. You have the legal power to make them stop contacting you completely with just one letter. The Fair Debt Collection Practices Act gives you the right to tell debt collectors to cease all communication, and they must comply or face federal penalties. This is called a cease and desist letter, and it's like having a legal restraining order against collector harassment. Once you send this letter, debt collectors can only contact you to confirm they received your request or to notify you if they're taking specific legal action like filing a lawsuit. But most seniors never learn about this powerful tool because debt collectors certainly won't tell you about it. They make money through intimidation and harassment. So why would they reveal the one simple action that can shut them down immediately? Let me tell you about Walter Thompson, 74, from Denver. Walter was receiving up to 12 collection calls daily from various agencies pursuing old medical debt. The constant phone calls were giving him anxiety attacks and disrupting his sleep. His blood pressure medication wasn't working properly because of the stress. Once Walter learned about cease and desist letters, he sent them to every collector harassing him. Within 2 weeks, his phone went quiet. The psychological relief was immediate. He could answer his phone again without panic, his sleep improved, and his blood pressure stabilized. One simple letter had restored his peace of mind. The letter doesn't make the debt disappear, but it eliminates the harassment. And if you're judgment-proof because you live on protected income, the practical effect is the same as if the debt never existed. They can't collect from you, and now they can't bother you either. Here's the exact language you need. I am requesting that you cease all communication with me regarding this alleged debt. This includes phone calls, letters, emails, and any other form of contact. If you continue to contact me after receiving this notice, you will be in violation of the Fair Debt Collection Practices Act. Send this letter certified mail with return receipt requested. Keep copies of everything. If collectors violate your cease and desist request, you can file complaints with the Consumer Financial Protection Bureau and potentially sue for damages. Now, let me address a fear many seniors have. What if ignoring these debts ruins my credit? Here's the reality. If you're living on a fixed Social Security income and struggling to pay basic expenses, your credit is likely already damaged. And here's what's more important. Bad credit cannot take away your Social Security benefits, cannot evict you from protected housing, and cannot garnish your exempt income. I've worked with countless seniors who worried about credit scores while sacrificing food and medication to make debt payments they weren't legally required to make. This is exactly backward. Your survival comes first, not your credit score. Furthermore, most collection accounts on seniors' credit reports are for old debts that are approaching the 7-year limit for credit reporting anyway. Negative items automatically fall off your credit report after 7 years from the date of first delinquency, regardless of whether you ever pay them. Consider this. At 65, 70, or 75 years old, are you planning to apply for mortgages or major loans? Most seniors' primary concern should be maintaining their protected income and preserving their basic living standards, not optimizing credit scores for loans they'll never need. I've seen too many elderly Americans live in poverty while maintaining perfect payment histories on debts they could legally ignore. They'd rather go without heat in winter than miss a credit card payment, even when that payment comes from money they need for survival. The debt collection industry has convinced seniors that paying these debts is a moral obligation, but the law specifically provides exemptions for people in your situation. Using these legal protections isn't wrong, It's your right. Your lawmakers created these protections because they recognize that people shouldn't be forced into destitution to satisfy creditors. Honor that wisdom by protecting yourself. Let me share the most important truth I've learned in my 32 years on the bench. The debt collection industry systematically targets seniors because they believe you won't fight back. They count on your generation's values of honesty and obligation to extract payments from income the law specifically protects. But here's what they fear most: informed seniors who know their rights and aren't afraid to use them. When you understand your legal protections, their entire business model collapses. Consider the bigger picture. You worked for decades, paid taxes, raised families, and contributed to society. You earned your Social Security benefits through years of employment. The government protects these benefits because they represent your safety net, money you need for basic survival in your golden years. No credit card company, medical provider, or debt collection agency has a greater claim to this money than you do. The law is crystal clear on this point. Your protected income is meant to keep you housed, fed, and healthy. Period. I want you to understand something crucial about the collection industry's tactics. They deliberately use language designed to make you feel like a criminal for using legal protections. They'll say you're walking away from your obligations or not taking responsibility. This is manipulation, pure and simple. The truth is, you're taking responsibility by ensuring you can maintain your basic living standards. You're being responsible by not impoverishing yourself to enrich debt collection companies that bought your old debts for pennies on the dollar. Every month that you send money to debt collectors instead of keeping it for rent, groceries, utilities, or medications, you're prioritizing their profits over your own survival. This isn't noble. It's self-destructive. Remember, these companies are not charities. They're not collecting debts to help the original creditors who have already written off these amounts years ago. They're private businesses that purchased your old debts as investments, hoping to pressure you into paying far more than what they paid to acquire them. When a debt collection company pays 5 cents for every dollar of debt they purchase, and then collects even 50 cents on the dollar from seniors like you, they've made a 100% profit. Your financial hardship is literally their business model. Here's my final advice. If you're living on Social Security, receiving pension benefits, or surviving on disability payments, you likely have powerful legal protections against most creditors. Don't let debt collectors convince you to give up these protections voluntarily. Stop making payments on debts you cannot be legally forced to pay. Send cease and desist letters to stop the harassment. Keep your protected income for your actual needs: housing, food, utilities, health care, and maintaining your dignity in retirement. If collectors threaten to sue, remember that even if they win, they cannot garnish your protected income. If they claim they can take your Social Security, they're lying and breaking federal law by making false threats. Document every interaction with debt collectors, record illegal threats or harassment, file complaints with federal regulators when collectors violate the law. You have more power than they want you to know. Most importantly, don't let shame or guilt override your legal rights. You're not stealing or cheating by using protections that lawmakers specifically created for people in your situation. You're exercising rights that exist precisely because society recognizes that seniors need protection from predatory collection practices. Your generation built this country. You deserve to live your remaining years with dignity, free from harassment by companies trying to profit from your fixed income. The law is on your side. Use it. If this information has helped you, please share it with other seniors who might be suffering in silence, making payments they don't legally owe while struggling to afford basic necessities. Now, let me tell you about the most dangerous trap that debt collectors set for seniors: the voluntary payment scheme. This is where they convince you to make small, affordable payments on old debts, not because you're legally required to, but because they make it sound like the right thing to do. Here's how this trap works. A collector calls about a 5-year-old credit card debt for $300. They know the debt is time-barred and they can't sue you. They know your Social Security is protected and they can't garnish it. So instead they say something like, "Mrs. Johnson, I understand you're on a fixed income. How about we set up a small payment plan of just $25 a month? That way you can take care of this debt responsibly." This sounds reasonable, even generous, but it's actually a sophisticated scam designed to extract money from your protected income. Once you agree to that payment plan, you've voluntarily given up your legal protections. Worse yet, in many states, making even one payment on a time-barred debt can revive it, restarting the statute of limitations and giving them fresh legal rights to sue you. I've seen countless seniors fall into this trap. Take Martha Williams, 77, from Phoenix. She was making $50 monthly payments on time-barred medical debt because the collector convinced her it was the honorable thing to do. Over 2 years, Martha paid $200 from her $100 monthly Social Security check, money she needed for medication and groceries. The debt she was paying wasn't even legally collectible anymore. When Martha finally learned about her protections, she immediately stopped the payments. The collector threatened to sue, but they couldn't. The original debt was time-barred, and her Social Security was protected anyway. She had been voluntarily impoverishing herself to pay a debt that had no legal force. This is exactly what the industry wants: seniors who voluntarily surrender their protected income. They don't need to win lawsuits or garnish wages if they can convince you to hand over your money willingly. Here's another variation of this scam. Settlement offers. Collectors will call and say, "Mrs. Smith, your debt is $5,000, but if you pay $500 today, we'll consider it settled." Or they make it sound like a generous discount, a once-in-a-lifetime opportunity to clear your record. But if you're judgment-proof, the real settlement offer should be $0. If they cannot legally collect from your protected income, why would you voluntarily pay them anything? They're essentially asking you to donate your grocery money to their collection agency. Remember Frank Morrison, 72, from Tampa? A collector offered to settle his $4,200 medical debt for $1,500. Frank was about to drain his savings to pay this discount when he learned that his Social Security income made him judgment-proof. The real value of that debt to collectors was $0 because they had no legal way to collect it. Frank kept his $1,500 and told the collector to stop contacting him. The psychological pressure here is enormous. Collectors are trained to make these offers sound urgent and generous. They'll say things like, "This offer expires at midnight tonight," or "My supervisor approved this special discount just for you." These are high-pressure sales tactics designed to bypass your rational thinking. Here's the key question you should ask yourself before agreeing to any payment plan or settlement. If this creditor cannot legally force me to pay this debt, Why am I voluntarily giving them money I need for basic survival? The answer is usually that you're being manipulated into believing you have a moral obligation that supersedes your legal protections. But the law specifically provides these protections for people in your situation. Using them isn't immoral. It's your right. Let me address something that keeps many seniors awake at night: the fear that ignoring debt collectors will somehow result in losing your home, your Social Security benefits, or being arrested. These fears are not just groundless. They represent illegal threats that debt collectors use to terrorize seniors into paying debts they cannot legally collect. First, let's be absolutely clear. You cannot be arrested for unpaid consumer debt, credit cards, medical bills, personal loans. These are civil matters, not criminal ones. When debt collectors threaten criminal action, they're breaking federal law. Debtors' prisons were outlawed in the United States in the 1800s. If a collector ever suggests you could face jail time, be arrested, or face criminal charges for unpaid debt, immediately document this threat and report it to the Consumer Financial Protection Bureau. This is a serious violation of the Fair Debt Collection Practices Act and could result in significant penalties against the collection agency. Similarly, threats to take your Social Security benefits are equally illegal. As I have explained, federal law specifically protects Social Security from garnishment by private creditors. When collectors threaten to take your benefits or garnish your Social Security, they're making threats they cannot legally carry out. Regarding your home, most states provide substantial homestead exemptions that protect your primary residence from creditors seeking to satisfy unsecured debts. Even if creditors sued you and won judgments, they typically cannot force the sale of your protected homestead to pay credit card companies or medical providers. But here's what you need to understand about lawsuits. Even being sued isn't the disaster that debt collectors want you to believe. If you're judgment-proof because you live on protected income, a lawsuit is essentially meaningless. They might win a judgment, but they still cannot collect from your protected assets. I've seen seniors panic over collection lawsuits and drain their savings to avoid court proceedings. This is exactly backward. If your income is protected and your assets are exempt, you should let them sue. They'll spend money on court costs and attorney fees to obtain a judgment they cannot enforce. Consider the case of Robert Chen, 71, from Seattle. Robert was sued for $6,500 in old credit card debt. Instead of panicking, Robert consulted with a legal aid attorney who confirmed that his Social Security income and modest home equity were fully protected under Washington state law. Robert simply filed a response stating his judgment-proof status. The creditor eventually dropped the lawsuit because they realized they couldn't collect anything even if they won. Robert spent $0 defending himself and kept all his protected income. The creditor spent hundreds in court costs pursuing a debt they couldn't collect. This brings me to another crucial point. Many law firms that sue debtors are looking for easy targets who won't fight back. When you demonstrate that you understand your rights and your protected status, they often decide pursuing you isn't worth their time and money. Here's a template response you can use if you're ever sued. Defendant is judgment-proof as all income consists of exempt Social Security benefits protected under federal law. Defendant has no non-exempt assets subject to collection. File this with the court and send a copy to the creditor's attorney. This simple statement often ends collection lawsuits immediately because it makes clear that pursuing you further would be a waste of resources. Now, let's talk about the emotional toll of dealing with debt collectors, the stress, anxiety, and sleep loss that many seniors experience from collector harassment can seriously impact your health. High blood pressure, depression, and anxiety are common among seniors facing aggressive collection tactics. Remember, your health and peace of mind are worth more than any debt. The law provides these protections specifically so you can live your remaining years with dignity, not in constant fear of financial predators. You have the legal power to stop the harassment, protect your income, and maintain your quality of life. Don't let debt collectors steal your golden years through intimidation and fear. Let me share something that might surprise you. Some of the most aggressive debt collection operations specifically purchase old senior citizen debts because they believe older Americans are easy targets who won't research their rights or fight back. They're counting on your generation's tendency to honor commitments, even when those commitments no longer have legal force. This targeting isn't accidental, it's a deliberate business strategy. Collection agencies analyze demographic data and specifically seek portfolios of debt from seniors because historical collection rates are higher among elderly debtors, not because seniors actually owe more money, but because they're more likely to pay debts they cannot be legally forced to pay. Understanding this predatory targeting should actually empower you. When you refuse to be an easy target, when you know your rights and assert them, these companies quickly move on to find someone more vulnerable. Your knowledge becomes your armor. Let me tell you about a powerful legal concept that can help you: debt validation. Under federal law, you have the right to demand that any debt collector prove you actually owe the debt they're trying to collect. This process often reveals that collectors cannot properly document their claims. Here's how it works. When a collector first contacts you, they must send you a written notice within 5 days explaining your right to dispute the debt. If you send a written dispute within 30 days, they must stop all collection activity until they provide validation, proof that you owe the debt and that they have the legal right to collect it. Many collection agencies cannot provide proper validation because they've purchased old debts without the original documentation. They're essentially trying to collect money based on spreadsheets and incomplete records, not actual contracts or account statements. Sarah Mitchell, 68, from Dallas, used debt validation to eliminate 4 different collection accounts totaling over $8,000. When she demanded validation, 3 of the 4 collectors could not provide proper documentation and were forced to stop collection efforts entirely. The 4th collector provided documentation that showed the debt had already been paid years earlier. Sarah spent nothing but the cost of certified mail to eliminate these collection efforts permanently. She learned that many collectors are essentially fishing expeditions, hoping seniors will pay without questioning the debt's validity. This is particularly important for medical debt, which is often sold to collectors without proper documentation. Hospitals frequently sell entire portfolios of unpaid bills to collection agencies, sometimes without maintaining adequate records of payments, insurance adjustments, or billing errors. If you're being contacted about medical debt, always demand validation. Ask for the original billing records, proof of what services were provided, documentation of insurance processing, and evidence that you're actually responsible for the remaining balance. You'd be amazed how often collectors cannot provide this information. For senior citizens, debt validation is especially powerful because your debts are often old, have changed hands multiple times, and lack proper documentation. Each time a debt is sold from one collection agency to another, the documentation becomes less complete and the collector's legal position becomes weaker. Here's the validation letter language you need. I dispute this debt and request validation as provided under the Fair Debt Collection Practices Act. Provide documentation showing 1. That I owe this debt, 2. The amount owed is accurate, 3. That you have the legal authority to collect this debt, 4. Copies of original creditor agreements or account statements. Send this letter certified mail within 30 days of first contact. Until they provide complete validation, they cannot continue collection efforts, cannot report the debt to credit bureaus, and cannot sue you. Remember, you're not asking them to prove the debt exists. You're requiring them to prove that you owe it and that they have the legal right to collect it. These are much higher standards than most collectors can meet, especially for old debts that have been sold multiple times. As we conclude today's discussion, I want you to understand that this information represents more than just legal advice. It's about reclaiming your dignity and peace of mind during what should be the most comfortable years of your life. Every month, thousands of seniors across America send money they desperately need for basic survival to debt collection agencies that have no legal right to receive it. They sacrifice medications, skip meals, live in cold homes, and deprive themselves of small pleasures because they believe they're morally obligated to pay debts that the law specifically protects them from. This isn't just financially tragic. It's a form of elder abuse that happens in plain sight, while debt collection companies profit billions of dollars annually from senior citizens' lack of legal knowledge. But now you know better. You understand that your Social Security benefits are protected by federal law. You know that old debts become time-barred and legally uncollectible. You've learned that being judgment-proof means creditors cannot force collection from your exempt income and assets. You understand your right to stop collector harassment with cease and desist letters, and you know how to demand debt validation that many collectors cannot provide. Most importantly, you understand that using these legal protections isn't dishonest or immoral. It's exercising rights that Congress and state legislatures specifically created for people in your situation. The debt collection industry has spent decades convincing seniors that you have a moral obligation to impoverish yourselves to satisfy their collection demands. They exploit your generation's values of integrity and responsibility to extract payments from income the law says should be protected. But consider this. The same lawmakers who created the moral and legal framework you were raised to respect also created these protections for seniors. When you use exemptions for Social Security, homestead protections, and statutes of limitations, you're honoring the law just as much as when you pay legitimate debts you can afford. The real moral question isn't whether you should pay debts you cannot legally be forced to pay. The real question is whether you should allow debt collection companies to profit from your financial vulnerability when the law provides specific protections against exactly this type of exploitation. Your remaining years should be spent enjoying the retirement you earned through decades of work, not living in fear of debt collectors who have no legal power over your protected income and assets. If you're currently making payments to debt collectors from your Social Security check, from your pension, or from savings you need for basic survival, I urge you to reconsider whether these payments are legally required or simply voluntary donations to companies that purchased your old debts as investments. If debt collectors are harassing you with phone calls, threatening letters, or illegal threats about your protected income or assets, You now have the knowledge and tools to make it stop permanently. You've worked hard, paid taxes, raised families, and contributed to society for decades. You've earned the right to live your golden years with dignity, security, and peace of mind. Don't let debt collection companies steal that from you through intimidation tactics that rely on your lack of legal knowledge. Remember Margaret Thompson from our opening story. After learning about her protections, she stopped all voluntary payments to debt collectors, sent cease and desist letters to stop the harassment, and kept her entire Social Security check for rent, groceries, and medication. Today, she lives comfortably within her means and sleeps peacefully at night. You deserve the same peace of mind. You have legal rights specifically designed to protect seniors from financial predators. Now you know what those rights are and how to use them. Share this information with other seniors who might be struggling with debt collection harassment. Together, we can ensure that America's senior citizens live their remaining years with the dignity and financial security they've earned and that the law protects.